Hi there. This presentation relates to the topic of lawyer self-regulation. I want to survey the different sources of the law of lawyering, and in particular, I'd like to give you a little bit of historical background on the ABA's rules of model rules of professional conduct and the predecessor versions, the earlier generations of those rules that have over time become very influential with state bar regulators. Lawyers are having this ancient debate about whether we are a business or a profession. Probably the most honest answer is that we're both. But what does that distinction mean? Sociologists have studied this in a great amount of detail, and we could go into a long path to answer that question, but let's take the short path. And in particular, let's look at what Roscoe Pound had to say about this. Pound was the dean of the Harvard Law School during the early decades of the 20th century and was really highly engaged with the American Bar Association and with the lawyers who were around at that time, putting together our sense of ourselves as a profession. And he described professions in this phrase you see up here as pursuing a learned art, so that's a key phrase, as a common calling in a spirit of public service. So notice that that as a profession, whether it be architects, doctors, lawyers, accountants, what have you, we share a common educational experience. All lawyers go to law school. And that we are trusted by the public to do some kind of public service in addition to the making a profit for making a living and making a profit in our business. Uh, Largely because the services that lawyers provide are complex and hard to evaluate over time. The thinking has been to allow lawyers to self-regulate rather than just depending on traditional market forces to do that regulation. And part of the self-regulation deal is that lawyers can be self-regulated, but only to the extent that they consider things in addition to profit, so long as you measure your bottom line in a way complex enough to account for the public good. Our professional responsibility rules were built on an assumption, a vision of a guild, lawyers who were a unified, a cohesive social group with similar interests, similar reactions. This vision of lawyers as a cohesive social group is nicely captured, I think, in Alexis de Tocqueville's Democracy in America in 1835. Remember, de Tocqueville came to the U.S. He was a French nobleman. He was asked to come to the U.S. to study prisons, which at that point was an American innovation getting attention around the world. And he started off to study prisons, but then he got more interested just generally in the new American democracy. And so he did deliver his report on prisons, but he also wrote what has remained one of the most penetrating, entertaining outsiders account of a new democracy, democracy in America. Along the way, he had some very interesting things to say about lawyers and the legal system. He famously said that in the United States, all important social issues ultimately become judicial issues. But here I want to focus on some of the things that de Tocqueville, here he is. Um, I'm not cutting his head off there. Let's give him let's just frame him a little more. There we go. So de Tocqueville said about lawyers, I won't read all of the bullet points here. The one I want to focus in on is this idea that that lawyers are an aristocracy, that they are, even in this highly egalitarian society, they have the mental habits of an aristocracy, even though they're not born as aristocrats. And de Tocqueville said that lawyers are temperamentally conservative, not in the political "who do you vote for" sense, but in the sense of having a commitment to existing institutions, being willing to work from the inside. So de Tocqueville had this vision of lawyers as being a cohesive class, really an aristocratic class, and that same vision, I think, motivated the early creators of ethics rules for lawyers. Now, this vision of a cohesive social group, lawyers esteemed by other groups, it was never entirely true, and it's surely become less true over the years. The cohesiveness of lawyers has weakened partly because of the shifting subject matter of the job, and also just the expanding variety of the social origins of people who have become lawyers. So you've got some numbers on the screen there from the American Bar Foundation. The 2005 Lawyer Statistical Report is the most recently available report. It was published in January of 2012. And these show up every 6 to 10 years. The bar is very good at commissioning these statistical studies, so we have nice snapshots over the years. So again, I won't read through all of the statistics here, but notice about 3/4 of lawyers are working in private practice. And then another 7.5% for government agencies, and then others who are in-house lawyers um, working for different corporate counsels offices and other private industry groups. And I think that this overall snapshot of the profession doesn't quite capture what's going on today, where I think there's more shifting away from private practice and into uh, both government positions and private industry positions, and folks who are using their law licenses but not necessarily practicing law. They're in business managing organizations and so forth. So I think if you look at the youngest cohort among lawyers, you'll see that that it doesn't look exactly like the general statistical profile here. One other note here. The story of the entry of women and racial minorities into the profession is a long and interesting one, and I just want to flag for you here that there are some great stories out there. In 1867, Iowa became the first state to license a female attorney, and by 1920, formal barriers for women's entry into the profession had mostly been removed, but that's only the formal barriers. By 1960, women still constituted less than 3% of the American bar. And as of 2000, females were about 27% of practicing lawyers. That number ticks up every year. As you may know, women are roughly half of the students entering law schools every year, just shy of half. Women tend to go into positions that are a little bit different from the ones that men go into. So they're a little bit less likely to work for firms, a little bit more likely to work for governmental organizations and so forth. But at any rate, this is a story of entry into the profession that is heading in a, I guess you would say, an inclusive direction, and I think of that as a positive story. The story of barriers for racial minorities has been a more discouraging one to my mind, and a persistent issue. The first African American lawyer was admitted to an American bar in 1844, and that was Macon Allen in the state of Maine. By 1890, blacks were less than 0.5% of the profession. By 1960, it was slightly over 1%. Currently, we're talking about maybe 4% of the bar are African Americans, despite roughly being 13% of the population. As for Latinos, as of 2011, about 3.5% of the bar are Latinos, and that compares to roughly 16% of the overall population. So there is still something of a gap for a profession that would aspire to, quote, look like America, one that would have a profession where clients could always find somebody who understands their point of view, their life experience, and so forth. But at any rate, those are two stories that are still in progress. The American Bar Association first shows up in the late 19th century, 1878. This is happening about the same time that everybody's jumping into professional associations. So you've got doctors forming their professional associations and accountants forming theirs, teachers, engineers, social workers. Lots of professional organizations are popping up in the late 19th century, and lawyers didn't want to get left out, so they jumped in as well. The ABA itself started off as really more of a social organization. Southern lawyers loved to travel to the Northeast to resort hotels such as the luxury hotel pictured here in this postcard that's reprinted on your slide. It's Saratoga in New York. But then after its initial years as primarily a social organization, the group got a little bit more interested in law reform, developing uniform laws, and so forth. The ABA has something of a checkered history early on. It was sort of infamous early in its history for opposing the nomination of Louis Brandeis to the Supreme Court. Not quite explicitly saying so, but just under the surface, objecting to the fact that he was a Jew, and so the ABA has kind of a mixed legacy coming forward, but we will be looking at some of its current products that I think by and large have been helpful for the legal profession. And so on the next slide, I'll give you some more, I guess, a more contemporary self-image of the organization. So here are some of the high-minded objectives of the current ABA. And I won't read through all of them, but I will ask you to read through them yourself and then ask yourself, how do these objectives distinguish the ABA from other trade groups like the Concrete Block Manufacturers Association or the House Painters of America or other, very numerous trade associations? A couple of self-limits that the ABA tries to respect. The ABA doesn't endorse or finance contributions to political candidates. And notice a lot of these objectives point to law reform, things that will improve the system as a whole, not directly trying to further the social or economic interests of its members. Obviously, a lot of the things that the ABA does will have a positive effect for lawyers and their livelihoods and their lives. But at least as a direct matter, what the ABA normally gets interested in is questions that lawyers have special expertise in that they believe will result in better operations of the justice system for the public. So the first ethical rules that came out of the ABA were based on a 1906 report from something called the Committee on the Code of Professional Ethics. This report was a reply to a speech by President Roosevelt, Theodore Roosevelt. So here he is, and TR had said that lawyers are in this business to protect their well-heeled clients. The reason we have lawyers is so that rich people get away with stuff. The ABA wanted to reply, and so they said, no, it's not that we're trying to get rich people to get away with stuff. And then they said, lawyers are high priests, and they are the keystones of the legal order. But they said, we do have a problem now. So we've got this influx of increasing numbers of lawyers, there are just more of us. And in this setting, our traditional tool, ostracism among the brethren, the professional brethren, that's not enough. The trouble is that now the shyster
the baratrously inclined, isn't that a wonderful word? Baratry would be the initiation of groundless lawsuits. So the baratrously inclined, the ambulance chase, the member of the bar with a system of runners pursue their nefarious methods with no check save the rope of sand of moral suasion. So this world is spinning out of control. The usual, raised eyebrow among like-minded fellows is no longer good enough to stop the unethical practices. And so we need something else. We need a set of rules. So what we get is a set of the canons of legal ethics, 32 of them initially, and they are adopted by 1920, so 1908 is the original year of the canons. By 1920, these canons were adopted by courts or legislatures to regulate the bar in all but 13 states. They spread remarkably quickly. And then 40 years later, by the 1960s, there were 47 canons, up from 32, and about 1,400 formal and informal opinions from bar authorities, from courts, and so forth. And they together formed a body of precedent that gave us the first real body of law for legal ethics. The second generation of ethical regulation from the ABA came in the 1969 Code of Professional Responsibility. Notice how the name is shifting. 1908, Canons of Ethics, it was ethics. Now in 1969, the slightly more neutral term responsibility. And the interesting thing about the 1969 code is that it's divided into three different kinds of statements. The first level will be the canons. These are statements of general axiomatic norms for the profession, just things that very general, statements of not just aspiration, statements of universal agreement. Lawyers, for instance, lawyers should keep the confidences of their clients. So that's the first level, canons. And then there's the level of ethical considerations. They were called at the time ECs. These were aspirational in character. So these were the kinds of things that lawyers should try to do whenever possible. But if you didn't do this, there wasn't going to be any real discipline. But then there were the DRs, the disciplinary rules, and this is the third level from the 1969 code. These were mandatory statements of the minimum level of conduct that marks the start of disciplinary action. If you cross this line, then bar authorities can come after you. So there were the canons, the kind of general rules, and then the more specific ethical considerations that were strictly aspirational, and then the disciplinary rules that were also specific, but that were absolutely required, that were mandatory. Then we get the third generation of ethical rules from the ABA, the 1983 Model Rules of Professional Conduct. And notice that the language has become even more neutral. So in this third generation, we've got a few new things going on in these rules. In the 1983 version, the drafters adopted the structure of the restatement, where you have an authoritative text of rules that tries to set out what the relevant institutions are actually saying, a descriptive statement of the rules, but with an effort to pick out the best among those actual statements of rules. So there's a bit of a normative edge to it. The authoritative text of the rules is accompanied by a non-binding commentary, just like the restatement. So in the 1983 rules, you get both text and commentary. Notice here they abandoned the three-tiered structure from the 1969 code. We no longer have canons and ethical considerations and disciplinary rules. Instead, it's just the text and commentary. And there's no place in this structure for aspirational standards. So the 1983 Model Rules of Professional Conduct were mostly drafted by Jeffrey Hazard, who's pictured here to the left. He happens to be a former law school teacher of mine. He taught both professional responsibility and civil procedure to the 1Ls. He's famous for coming into class the first day of class for 1Ls and saying, "Good morning, I'm Jeffrey Hazard, werewolf." He was known for being quite a demanding professor, so we'll give him some teeth here. Oh, that's not very, two fangs. So anyway, Jeff Hazard is the reporter for the 1983 rules, and what does he hope to accomplish? He mostly says that we want to make these rules more realistic. We want to stop with the moralizing. We want lawyers to be subject to law just like other groups of professionals. And in particular, he wanted the model rules to integrate other sources of legal regulation and to defer to those other sources. So about this same time, the ALI, the American Law Institute, is trying to develop a restatement of the law of lawyering for the first time. Because courts were always issuing rulings in malpractice cases, in criminal cases, in lawyer disciplinary matters that were appealed from bar authorities. And so there is a body of law that you can restate according to the usual restatement practices. And Hazard wanted to account for that in some way and to give a realistic view of what legal institutions will require of lawyers. So he tried to embody that in the 1983 Model Rules of Professional Conduct. Notice conduct now without that ethical edge to it. It's just, this is what the law requires of us. Here's an example of the differences between the 1969 Code and the 1983 rules. So under the 1969 Code, we have EC 227 over here, the Ethical Consideration 227, that says that a lawyer shouldn't decline representation because a client or a cause is unpopular. And contrast that with the Model Rule 6.2 that says a lawyer shall not seek to avoid appointment by a tribunal. Notice it's not just generally don't represent somebody, but if the court knocks on your door and says, I want you to represent a person, you shouldn't do that unless you have good cause. But the good cause is not specified, where over with the Model Code. Specifically, it talks about unpopularity. So the model rules are give you a more specific situation. The court is knocking on your door and gives you a more general standard to apply. You have to have good cause for refusal. In general, the model rules try to aim for legally enforceable settings where the rules will apply. So what do we gain and what do we lose by moving from this more morally based set of rules from 1969 to the more sort of legally enforceable rules from 1983? Would we be better off if we just said, as long as we're relying on these legally enforceable rules, would we be better off just relying on external regulation, just like doctors are regulated from the outside? Perhaps lawyers should be regulated from the outside. How would you get more public involvement in the formation of rules that apply to lawyers? Is it more appropriate to move away from this self-regulation? For instance, in New South Wales, regulation can come from an independent, something called a legal profession council, where lay members are part of the panels that describe what is required of lawyers. So, it's it raises an interesting model as we move to the emphasis on legal enforceability of the ethics aspirations when we moved from the 1969 code to the 1983 code. Now, the 1983 rules have not remained static. So the ABA first amended the 1983 rules through an effort called Ethics 2000 that was chaired by this guy, Norman Vesey, who actually is a former Chief Justice of the Delaware Supreme Court and is a sometime faculty member, visiting faculty member at Wake Forest, who teaches a very fine course in the ethics rules that apply to corporate counsel. These days he's in private practice, representing various corporate clients, and takes time out from his schedule in Wilmington, Delaware, to teach Wake Forest students. I encourage you to take his class. At any rate, he was the chair of the ABA Ethics 2000 effort, and that effort involved a handful of things that you see described in the text on this slide. I won't read through all of those, but it was a basic recalibration. In general, the ABA Ethics 2000 committee placed less weight on duties to clients, particularly confidentiality, and it increased lawyer obligations to third parties. So it shifted some of the lawyers' attention away from the client to some people outside the lawyer-client relationship. And it also gave lawyers more latitude to prevent social harm. It opened up some larger exceptions to the confidentiality requirements for clients, and in general told lawyers to value social harms a bit more than the old rules had allowed them to do. The more recent effort by the ABA to amend the ethics rules takes the form of an effort called the Ethics 2020 Commission. It is chaired by two people, really classic insiders. So first there's Jamie Gorelick, who was a Clinton administration Department of Justice official, now a lawyer in private practice in D.C. And then there's Michael Traynor, who is a former official involved with the American Law Institute, the folks who put together the various restatements of the law, the restatement of torts and contracts and so forth. These two together have chaired the Ethics 2020 Commission, and they met for the first time late in 2009. 2020 is designed not so much to, it's really not aiming to state a date, that the ethics rules will be relevant through 2020. Instead, it's an effort to say we want to see clearly, we want to see current reality with 2020 vision. The commission met for the first time late in 2009, and it held its first public hearings early in 2010. Its efforts are still going on, and so in August of 2012, it put several of its recommendations in front of the ABA House of Delegates. So its work is now starting to show up in concrete amendments to the 1983 rules. There are two basic forces that Ethics 2020 is trying to deal with. Those two forces are, first, globalization, and second, technological change. In particular, technology is driving some refinements in the confidentiality rules, and so the Commission is focusing in particular on the impact of technology on smaller firms. As for globalization, the second big force that the Ethics 2020 is trying to deal with, globalization is stressing some of the traditional limits on firm affiliation and joint ownership with non-lawyers, a topic that we'll talk about a bit later, something called multidisciplinary practice. European lawyers have a lot more latitude than American lawyers to practice law in alternative business structures that are partially owned by accountants and other non-lawyers. And so these questions of multidisciplinary practices are important to the Ethics 2020 Commission, largely because of the impact of globalization.